Senator Middleton, do you yield?
I do, thank you.
When we're not in legislative session, I am a land use attorney. And often I am in far-flung areas in blue jeans, cowboy boots, and a hat going to visit somebody's ranch who's looking for a conservation easement or trying to defend themselves against a eminent domain case, for instance. So if I'm in some far-flung county and I'm in the courthouse dealing with a property, some kind of property filing, and I'm in blue jeans and cowboy boots and a hat, and I am nearly 6 feet tall, and I have very short hair, and I walk into the women's room. Am I making that county vulnerable to prosecution, civil prosecution under your bill?
No, you're not.
Don't you think it is at least probable that somebody's going to mistake me for a man? It's happened a lot. You can go ahead and say it. I'm not embarrassed by it.
No, this is not a good example because I'm certain what your ID shows is that you're a woman.
I don't have my ID on me in this hypothetical, and I certainly don't have my birth certificate.
So you're doing legal work without it. Well, I don't know what you're carrying or not carrying or how you drove there to the courthouse, but it's interesting. No driver's license to drive there.
Okay, let's say I am carrying my driver's license. So someone stops me and says, "Excuse me, sir, you can't use that bathroom." I have to show them my driver's license in order to prove up that I am a woman to go into the bathroom?
Not necessarily. It gives them an opportunity to cure if there's a complaint that is substantiated, which this wouldn't be because clearly you are a woman, right? There would be no civil penalty. That's easy. It's easy.
But still, I'm going to have to prove up to somebody that I'm not a man before I go in and use that multi-stall bathroom, right?
Not necessarily. There's no mandate on the county. There's no mandate on the city. There's no mandate on the school district. They have to adopt a policy that designates these private spaces according to biological sex, and that's it.
So let's say I repeatedly use this, county bathroom, Blanco County, let's say. And I'm doing some work there over a series of months, and somebody keeps seeing me walk in and assumes I'm a man and brings a complaint up to the Attorney General's office. How do they prove that complaint?
They can't bring it to the Attorney General's office before they brought it to the political subdivision of the state.
Okay, so they bring it to the political subdivision of the state. In this case, it's the county, and says, "I see this man walk into the woman's room all the time, and y'all don't do anything."
This is fairly simple,
The county's
Senator.
supposed to prove this allegation.
Senator, this is very simple. You're creating a level of bureaucracy that is not in this bill. It's not in this bill. That's not what this bill does.
Well, I'm just wondering how
You're
you
reading
actually
into it
prove
and it's
up
not
one
there.
of these civil offenses.
You're reading it into it and it's just not there. That's just the bottom line.
How does an individual who thinks that they are seeing men walking into the women's room in the Blanco County Courthouse all the time, how does that case get proved up?
You have to submit a complaint.
Right. And then how does the recipient of the complaint investigate whether the complaint is valid? Do they have to go find each one of these alleged men who walked into the women's room and determine whether they are actually men?
That is up to our local political subdivisions of the state to determine the process they deem most appropriate, and also our state agencies.
So that's what you mean by, let me see, it's page 2, line 36, every reasonable step.
Reasonable, yes.
So if somebody just comes to the county commissioner's court and says, "I'm pretty sure men are walking into your courthouse women's room," the commissioner's court needs to take reasonable steps to make sure that that's not occurring.
That's also related to the opportunity to cure, but it sounds like in this case there is nothing to cure because you're the one going to the women's restroom, as you always have been apparently, So
I want to go back to something that Senator Gutierrez asked about because it's curious to me that on page 2, as you told him, page 2, line 22, this chapter may not be construed to prevent a litigant from asserting the invalidity or the unconstitutionality of a provision. I see that plain black and white right there, and I appreciate that. But how do you square that with page 5? Basically, your bill says you're not barring a litigant from making the assertion, but you are barring the state court from having jurisdiction over that assertion and making any kind of ruling with regard to it, much less certifying a class of people like me who've just trying to go to the bathroom and keep getting barred because somebody's asking whether or not we're women.
Well, then you got to go back to page 4, and it allows immunity to be abrogated or preempted by federal law.
So you can't bring this suit in state court, is what you're saying?
It depends on how you frame that, Senator. You got to go back to 3001 on page 1. You possibly could. You can make the allegation in state court, but state court can't have jurisdiction over the constitutionality. It's intended for federal court.
So, your answer to my question is you cannot bring a suit under state constitutional provisions by this bill. You bar a challenge under the state constitution by this bill.
You can bring a lawsuit, Senator. You can bring a lawsuit based on the constitutionality being challenged. You can. It says that very clearly. You're reading something that's not in there.
No,
you have
it is
to
very
read it
clearly
together.
on page 5.
You have to read this together. You have to.
I beg to differ. How can you say on page 5 that a state court has no jurisdiction and cannot award declaratory or injunctive relief?
That's related to the enforcement and not the constitutionality.
Mm-hmm. So, it does not apply to the plaintiff. Section 3001.002, this chapter may not be construed to prevent a litigant from asserting the invalidity or unconstitutionality of a provision or application of this chapter as a defense to liability in an action claim or counterclaim brought under this chapter. At the end of the day, Senator Middleton, why are you creating this civil cause of action around bathrooms that violates the separation of powers between the legislative and the judicial branch and creates a claim that probably can't be proven? Why are you doing this?
For safety.
Because you think that there is just you've stated no statistical basis for some imagined danger that is rampant across the state of Texas. But I respect that you are afraid of that. I respect that you are afraid of that. And frankly, I prefer having a women's bathroom. Frankly, I prefer having a one-holer, and most people do. I don't think that we'll be able to afford to have one-holers for everybody in all government buildings, but it sure would be nice. But thank you for answering my questions.